Ecum et bonum est lex legut. What is just and good is the law of the law. Apa yang adil dan baik adalah hukumnya hukum. Hello everyone, in this video I will discuss the criminal law in Turkey. Before proceeding to discussion, let me introduce myself. My name is Radja Triand Wijaya with name 23080100304 and my letter is Miss Dina Sylvia Putri SH MKN. Let's start it. The material that we will discuss is as follows. The first is the country of Turkey, the secondly is definition criminal law, and the third is the criminal law applicable in the country of Turkey. First, the country of Turkey. Turkey has a legal system that is integrated with the legal system followed by constitutional era. The legal system in Turkey is based on constitution, laws, and court decisions. Turkey has three types of courts, namely the Supreme Court, the Court of Appeal, and the Court of First Instance. The Supreme Court is the highest court in Turkey and is authorized to review decisions of the Court of Appeals or special court decisions. The Court of Appeal has the authority to review the decisions of the Court of First Instance, while the Court of First Instance is a court that handles civil and criminal cases. In addition, Turkey also has a constitutional court that has the authority to test the constitutionality of laws and government decisions. Turkey also has a criminal law system that includes the death penalty for criminal acts such as murder and rape. However, no criminal has been executed under the death penalty since quite some time. Turkey also has laws criminalizing violence against women, including rape, sexual harassment, and physical violence. Next, the second, definition criminal law. The following is the definition of criminal law according to legal experts. First, Mr. W. P. G. Pong. Criminal law is the overall rule of legal provisions regarding punishable and acts and their punishment. And the second, C.T. As Council is criminal law is the law that regulates offense and crimes against the public interest, which actions are punishable by punishment, which is a suffering of torture. Next, 3. The criminal law applicable in the country of Turkey. So, the first is the history of criminal law in Turkey. First is Ottoman Islamic criminal law system. The Ottoman Islamic criminal law system was based on the millet system, which allowed different religious communities to maintain their own legal system. The Ottoman Empire had a complex legal structure, and Islamic law played a significant role in the administration of justice. The second is transition to modern criminal law. The Turkish Republic introduced significant legal reforms, including the adoption of the Turkish Penal Code, which aimed to abolish prior laws and establish a new legal system. This marked a shift from the traditional autonomous Islamic legal framework to a more modern European-influenced legal system. Third is current legal system. Today, Turkey operates under a civil law system, with its legal framework drawing inspiration from various European legal systems. The Turkish legal system is primarily based on the constitution, with the Turkish Criminal Code and the Turkish Code of Criminal Procedure serving as the two substantive national sources of law criminal matters. Fourth is European Union harmonization. In recent years, Turkey has been working to harmonize its criminal laws with European Union standards. This includes efforts to bring the existing penal code and criminal procedure code to a level acceptable to the European Union. In summary, the history of criminal law in Turkey reflects a transition from the Ottoman Islamic legal system to a modern, European-influenced legal framework with ongoing effort to align with European Union standards. Next, the source of criminal law in Turkey. First, Constitution of Turkey. The Turkish constitution serves as the primary source of law in Turkey, providing the foundational legal framework for criminal law and justice. The second, Turkish Criminal Code or TCC. The Turkish Criminal Code is a substantive national source of law that governs criminal matters in Turkey. It provides the legal framework for defining criminal offense and prescribing penalties for unlawful conduct. Third, Turkish Code of Criminal Procedure or CCP. The Turkish Code of Criminal Procedure is another substantive national source of law that outlines the procedural framework for investigating and prosecuting criminal cases in Turkey. Fourth and last is international treaties. International treaties also contribute to the source of criminal law in Turkey. As a member of various international organizations, Turkey is bound by international agreements and treaties related to criminal law and justice. These sources collectively form the foundation of criminal law in Turkey, providing a comprehensive legal framework for the regulation and adjudication of criminal matters. The principle of legality, nulla poena sine lege, is respected in Turkey as a safeguard of personal liberties, ensuring that only clear and specific laws are in place before individuals can be punished for criminal offenses. Next, criminal law system in Turkey. First, legal system. The Turkey legal system is a civil law system based on various European legal systems, with the constitution being the primary source of law, followed by laws, law amending ordinances, and international treaties. Second is primary source of law. The two substantive national sources of law relevant to criminal law in Turkey are the Turkish Criminal Code or TCC and the Turkish Code of Criminal Procedure or CCP. Third is principle of legality. The Turkish Criminal Code upholds the principle of nulla poena sine lege, or no punishment without law, ensuring that no one shall be punished for an act that is not defined as a crime by law. Fourth is judicial system. The Turkish judicial system is divided into civil and criminal divisions, consisting of the constitutional court, civil courts, and criminal courts. 5. Legal profession. In Turkey, any individual who has graduated from a law faculty at a university can become an attorney at law, judge, prosecutor, or notary after specified terms of internship. 6. International judicial cooperation. Turkey provides international judicial cooperation as central authority on civil and criminal matters, including procedures such as notification, retention, extradition, transfer of convicts, and transfer of prosecutions. Next, the principles of criminal law in Turkey. The principles of criminal law in Turkey encompass several key aspects as evidenced by the Turkish Penal Code and legal resources. First is protection of fundamental values. The Turkish Penal Code aims to protect individual rights and freedoms, public order and security, the rule of law, public health, and the environment, the protection of social peace, and the prevention of crime. Next, the second, principle of legality. The principle of legality in crime and punishment is enshrined in the Turkish Penal Code, ensuring that no one can be punished for an act that is not considered a crime by law. Third is individuality of criminal responsibility, intent, and recklessness. The Turkish Penal Code recognizes the individuality of criminal responsibility, intent, and recklessness, emphasizing the personal culpability of the offender. Fourth, no criminal punishment based on regulatory transactions. The Turkish Criminal Code prohibits the imposition of criminal punishment based on regulatory transactions of the administration. 5. Application of Turkish laws to Turkish citizens committing crimes abroad. Turkish laws apply to Turkish citizens who commit crimes abroad, ensuring that they are subject to Turkish law if the offense requires punishment according to Turkish laws and the offender is found in Turkey. Next, the judicial system of criminal law in Turkey. The criminal justice system in Turkey is defined by the Turkish Penal Code and the Turkish Constitution. The Turkish judicial system is divided into civil and criminal divisions consisting of first instance courts, regional courts of justice, and heavy criminal courts. The principles of the Turkish criminal justice system include the protection of fundamental values, the principle of legality, and the individuality of criminal responsibility. The Turkish Penal Code aims to protect individual rights and freedoms, public order and security, the rule of law, public health and the environment, the protection of social peace, and the prevention of crime. The Turkish criminal justice system is committed to upholding the rule of law, protecting individual rights, and ensuring the fair and just application of criminal law. Efforts have been made to exchange the knowledge and skills of legal professionals in applying European human rights in the field of criminal justice and to improve cooperation and awareness among relevant national institutions, as well as enabling access to criminal justice for all citizens. The Turkish criminal justice system is funded by the European Union and the Council of Europe, with the main objective being to strengthen and make the Turkish judiciary more efficient, effective, and feasible. The heavy criminal courts consist of 3 judges and are responsible for handling offences and crimes involving a penalty of 10 years of imprisonment. In summary, the criminal justice system in Turkey is committed to upholding the rule of law, protecting individual rights, and ensuring the fair and just application of criminal law. Efforts have been made to change the capacity of justice professionals, align Turkish laws with international and European standards, and improve access to criminal justice for all citizens. Next, criminal law cases in Turkey. So, one notable murder case in Turkey is the murder of Özgekan Aslan, a 20-year-old university student who was brutally killed in 2050. The case gained widespread attention and sparked public outrage, leading to significant legal developments. The perpetrator Ahmet Supi Altidokan was found guilty of the murder and sentenced to aggravated life imprisonment, which is the most severe penalty under Turkish law. The prosecutor demanded the harshest possible sentence under Clause 3 of the Turkish Penal Code, claiming that the murder was a case of monsters, and torturous homicide, which disqualified the perpetrator from seeking parole. This case became a cause celebrated in Turkey, highlighting the issue of violence against women. The brutality of the murder led to widespread public outrage, with thousands of protesters taking to the streets across Turkey. The resolution of this case demonstrates the application of Turkish criminal law, particularly the severity of punishment for intentional killing. The perpetrator received the most severe penalty available under Turkish law, reflecting the gravity of the crime and the commitment to justice in addressing such heinous acts. This case underscores the importance of upholding the principle of criminal responsibility and the protection of individual rights and freedoms. As outlined in the Turkish Penal Code, it also reflects the Turkish legal system response to addressing serious criminal offenses against life and ensuring that perpetrators are held accountable for their actions. That's all the explanation for me. If there are mistakes in words, please forgive. Thank you for your attention. That's all the explanation from me. One legal adage from me, it's fakta sunt potentiae verbis, yang artinya perbuatan atau fakta lebih kuat dari kata-kata. Goodbye and see you.